The next case to come before the court is Maria Matheson v. James Matheson. Each party will have up to 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know, so I'll be keeping track of time. The arguments are being recorded, so please stay behind the podium and keep your voices up. Introduce yourselves. You should not use the names of children or minors or victims during your argument. You can refer to them by initials or generic terms like the child, children. The judges have read your briefs and we're ready to proceed when you are. I would just ask the appellant, would you like to reserve time for rebuttal?
Thank you, Your Honor. Yes, I'd like to reserve the 5 minutes.
Very well. You may proceed when you're ready.
Thank you, Your Honors. May it please the court, my name is Danielle Kulik, and I represent the appellant, Maria Matheson, in this matter. I want to start with the judgment that we are going to pay $200,000 to the creditors. For me, this is vague. Which creditors? It is well documented in the transcripts, in the evidence, and in the judgment entry itself that all the creditors that existed at the time of the filing of the case had been paid off, where Dr. Matheson was robbing Peter to pay Paul, as they called it, moving all the funds around against the mutual restraining orders. So the $200,000 is going essentially back to Dr. Matheson to pay him back. And the problem with that is next, it shows in the record that they testified at the time of filing the case, there was Citi, Sam's Club, GM, Costco, and that's it. It was less than $100,000. They also talked about the affidavits that were filed in the matter, and the affidavits had those same ones, Citi, Sam's Club, GM, Costco, and added a Lightstream and a Best Egg that existed at the time of filing. Again, under $100,000 total. The judgment entry itself does even state this. On page 60 in the judgment entry, it says there was less than $100,000 of marital debt at the time of filing. Then if you go to page 61, all of a sudden there's now $200,000 of marital debt existing at the time of filing.
Counsel, I
Yes.
hate to interrupt you, but I want to just understand this a little bit more. So does the judgment entry, did the court make a finding regarding the allocation of the marital debt? Did the trial court say, calculate the debt, say what the debt was, applicable for and what should be paid?
No, they didn't at all. If you look at page 60 and 61, all it notes is that Mr. Matheson is to pay the debts that he incurred during the divorce proceedings because it was against mutual restraining orders and without Maria Matheson's consent, and it totaled over $1 million in debt he was moving around. There was no calculation. It didn't say where they got the $200,000 from. It doesn't say how they're going to pay the $200,000 back. It just says pay the creditors $200,000 from the sale of the marital home.
And
it
how
doesn't
much,
say.
how much were the proceeds from the marital home? Was that $200,000 or?
$330,000 was being held in escrow from the marital home. So out of that $230,000 was going to pay Dr. Matheson back for moving marital money around when there was only $100,000 of debt at the beginning of the marriage, less than $100,000. And then he created this marital waste during the case, moving these things around. So that's first and foremost. Secondly, when he's moving all these things around, he didn't provide any documentation to show where these things were going. He provided handwritten notes to the court, just, same as this. Handwritten notes saying what he used them for. The notes, even detailed in the judgment entry, were inaccurate. He said he paid the same thing twice with 2 different loans. The notes were not supported by any evidence, and further, it also
testified, I assume he testified as to what was in those notes himself. That would be some evidence, here's what I did.
It is some evidence, but he's just not credible. As noted, that he's saying that he paid the same thing twice. He's saying he paid certain things, and then also, what he's saying he paid doesn't add up to how much he took out. He actually hid $70,000. He testified. They said, there's $70,000 still remaining, even from your notes, for what you said you paid. Isn't there $70,000? And he said, yes, there is. That went to his own bank account. This Fifth Third bank account that he even testified he didn't disclose in discovery. He never provided a single bank statement from this Fifth Third account.
So he was just testifying based on his recollection and not with corroborating documents?
Correct.
It's a law court decision, so I apologize. Did the court make specific findings as to what each of their individual bank accounts were
No.
valued at?
No, there was no finding of what either bank account was valued at. They said, go ahead, you keep your own bank, she'll keep her own bank since you started it at the beginning of the divorce case. Even though we know in Ohio, you divide the assets at the end of the case. There was never a finding how much was in her account, never a finding how much was in his, and as we know, he nets over $30,000 a month in his income. And then he moved that $70,000 to his account. The court even found in their judgment entry, he moved another $100,000 from the loan around.
Did the court find those accounts that were in their individual names to be separate property or marital property?
They were marital property. They did not find them to be separate. Yeah, they were not listed under the separate property section.
Did the court make findings about what was marital property?
Yes.
I mean, okay.
Yes, they did. So there was a few things that were argued as separate property. One of them was my client's Scott trade account, which was an inheritance that she used to pay her attorney's fees, and it was ruled to be her separate property, and she kept it. Mr. Matheson had testified about a few other accounts that he had, and they were found to not be traced to be separate and commingled, and those were actually deemed marital property and equally divided. There was no argument made that these other accounts should be separate, the Huntington and the Fifth Third. And further, again, he hid it from discovery, he hid it from the court, and wasn't very credible. I believe the fact that my client was receiving $4,300 a month in spousal support, paying rent at $2,500 a month, and also she even testified, she had $42,000 in medical debt to pay. She had $2,000 in the child's piano lessons to pay. She had all this to pay. Her account had nothing in it. She was 2 months behind on rent. She was getting evicted. She got to keep a negative bank account, and he got to keep all of his hidden money, all of the $30,000 a month he nets in his income. And then when we go to spousal support, they sold the marital home during the case, and he was ordered to pay the rent, utilities, all these things for the marital home. When she moved out, he's not paying those rent and utilities at her rental. So again, she's using her own money for this. Her spousal support did not increase as it should have. They filed that motion for retroactive support increase that was denied here. And it should have been granted because he should have been paying her living expenses as the court
She
intended.
moved to modify temporary support after the house was sold, and then that was denied, is that correct?
Yes. Yep, the house was sold, she moved out, she filed a motion to increase the support. Because the support was, again, $4,300 plus he was to pay her living expenses, but it said at the marital home. So again, that might have been a mistake by the court, and she tried to correct it, but the court didn't correct their mistake, and they never gave her her living expenses. Now, at the end of the case, of course, she is getting more money in spousal support. We've now gone, we've doubled, we've gone up to $8,500. We're doing, slightly better, but again, he nets $30,000 a month. This is a 32-year marriage. They got married in 1989. She homeschooled 9 children, and to this day, she still has the one child in her home, which was not really testified much about. She did testify that the child had fetal alcohol syndrome, and she takes the child to counseling and therapy, and she takes care of all that. That one, again, whether there should have been any order of child support for an adult child with issues wasn't discussed with the court, but it is something that can be considered when we're looking at spousal support and what she has to do every day. The fact that the court wants her to get a minimum wage job when she hasn't worked in 40 years, and she's 56, they've given her support for 7 years. They're saying at the end of the 7 years when you're 63, go get a job for the first time in 40 years. She can't, she hasn't worked, who's gonna hire her? And also, we want her to be able to live the standard of living she became accustomed to. The standard of living he's going to be living. And she can't live that standard of living at the income level she was given, and with only 7 years of support for her 32 years of marriage, raising 9 children and homeschooling them. That was inappropriate for the court to order. And it shows in the record also that Mr. Matheson had sold his medical practice in 2019. The parties separated in 2019. The divorce was filed in 2019. He had that medical practice since 2001. and all of a sudden he sells it, and the court didn't make any findings about whether or not that was appropriate for his income. So you're gonna read that, yeah, his income looks a little bit lower now because he sold his medical practice that he had for 19 years when he decided to
I
file.
thought his income went up in 19 and 20, we started working on the job after he sold his practice, isn't that what the evidence shows?
The evidence showed that his W-2s were in like the 30,000, the W-2s showed in the 300,000 range. But yeah, there was testimony that he was still getting dividends from his old practice. I think when people paid their old medical bills, he was still getting some dividends.
So his work income was 300, and you were saying he received other income that raised his income?
Yeah, I believe there,
20 and 21, or
Yeah.
whatever you're talking about.
I believe there was that, and then he also, it said with working with his practice, he did other jobs on the side as well with his medical practice, through the practice. So yes, the court did find that he had that income of about 600,000, which is correct. And again, putting my client to work for a minimum wage to make her pay the rest of her debts and the rest of her living expenses and everything, and giving her only 7 years is contrary to Ohio law. And especially when the court even notes that.
It's contrary to Ohio law how?
It's contrary because we want her to have the standard of living that she was used to during the marriage. We want, in case law, we know that we can have this indefinite duration.
But is that mandatory or is that just permissive?
It's permissive, yeah, it's not mandatory, but in the case, I couldn't think of a more important case for it to happen than this case, where she homeschooled 9 children, 30 years. The idea that she wouldn't get lifetime support is for me, I don't believe it's what would be equitable.
And they had made a decision, right? There was evidence that there was no contesting the fact that they had both decided she would stay home and raise and school the children.
Correct, they had stipulated to that, so they didn't even need to testify about it. They stipulated that they agreed she would stay home and raise the 9 children, and that she would quit her job, and that was agreed at the time, that they did that.
And we're reviewing this on an abuse of discretion standard, would you say, on the trial court's award of spousal support?
Yes, this is all for abuse of discretion, and I believe the court did abuse its discretion. They note in here, they want to do what I'm saying, they want to give her more, they want to, but they note he gets a windfall. They said the word windfall on page 60, he is getting a windfall for the money that he moved around, for the money that he hid, and they do nothing with that. The court says he gets a windfall, and they just set that aside. The court gives him his bank account, they move on. I think there was just so many moving parts here that at the end of the day, when this decision was written, I think they missed a few things, and I think it was an abuse of discretion. I think they knew what they were looking for, they knew what they were trying for, and we missed the mark there on this judgment entry because we know he hid that bank account and how much was in it. We know that was never disclosed in discovery. We know he hid money he moved around.
I just want to let you know that you have moved into your rebuttal time.
Oh, okay, my apologies, thank you, Karen. All right, if there's nothing else then.
May it please the court. My name is Vincent A. Stafford. I want to thank the court for the privilege of appearing before the panel, and I also have the privilege of representing Dr. Matheson through this entire saga of this divorce from 2019 to present. I would note that this was a 14-day trial. Again, that was presented to a very well-seasoned and I believe well-respected jurist, Judge Janik. The case from inception, Ms. Matheson had, through the divorce, 3 separate attorneys from 3 separate law firms. She engaged in what was described by the court as a Machiavellian attempt to cause chaos and scorched earth litigation in this case. The parties married in 1989. Dr. Matheson was a young physician. Ms. Matheson was a nurse. They decided to raise a very large family, and they did that. Ms. Matheson dedicated time and raised the children. They had 8 natural children, 1 adoptive child who's now emancipated and an adult. Some of the kids were homeschooled, some of them went to private school. All of them have done very well as adults, physicians, professionals, military. All of the evidence will show all of the adult children are alienated and disconnected from Mrs. Matheson. The evidence was clear, unfortunately. There was a significant mental health issue.
That is unfortunate. How does it play to the assignment of error in this case? I mean, I appreciate you want to tell us that, but how does it involve our assignment?
It's important because of what went on in the pretrial litigation. The Mrs. Matheson engaged in conduct in violation of court orders of hiding a minor child for several months.
Excuse me,
Yeah.
counsel, so did that, was that reflected in the judgment entry?
It was not, because the parties during the midst of the trial resolved the allocation of parental rights and responsibilities, where Dr. Matheson was awarded the residential parent and legal custodian status. So going back to the arguments of the appellee, Dr. Matheson had his own private practice as an OBGYN in Lorain and Erie counties. The evidence showed unequivocally that while he made approximately $250,000 a year, the parties with their large family spent almost every single dollar that was earned, including paying for colleges for 6 children at that point. If you look at the assets of the parties, despite Dr. Matheson having a successful medical practice for over 20 years, they didn't have any assets. There's no bank accounts to speak of.
Counsel, can you just
Sure.
answer the question that I also asked the appellant about whether or not the trial court actually made a finding related to how much marital debt there actually was?
There was the reference, I believe, to that there was $240,000 of marital debt that the parties had. And the panel, you need to understand, each year, and it's important to note, because the appellant has indicated that there was only $100,000 worth of debt. The parties did not pay taxes from the employment income of Dr. Matheson. They didn't make quarterly payments. They would get walloped with a $40,000, $50,000, $60,000, $70,000 tax bill in April. And so what's happened, members of the panel, is that you had this debt of taxes that IRS was charging, I think, 24%. The parties would consolidate these debts, borrow money, either on a zero interest credit card. When the grace period would run out, they would roll it over to a new zero interest credit card.
And you're saying they, but it was really Dr. Matheson who was tasked with that?
Well, he was obviously tasked with that because he handled certain financial matters, but that was the evidence showed, and the testimony was very clear. They would literally rob Peter to pay Paul when these taxes came due. They would have to figure out how they're gonna pay the IRS. I think the testimony was the IRS physically came to their house at one juncture. So the issue was you had this $240 worth of debt. The record would reflect that there were requests to consolidate, to refinance the house during the litigation, because alone, their interest payment alone during the divorce was almost $8,000 a month on the debt service. So this was a real, very real problem. There was no secret what the money was being used for. Dr. Matheson testified in details for extensively and included direct questions from Judge Janik. Why was this debt consolidated? What did you use the money for? It wasn't for the benefit of Dr. Matheson. So at the end of the day, the court made a determination that there would be $200,000 assigned for marital debt that would come out of the sale of the marital residence. During the litigation, Dr. Matheson, all in, starting in about 2019, was paying $20,000 a month in support obligations to maintain Mrs. Matheson's house, to pay for the vehicles, to pay the debt service, to pay the interest. There was constant requests for relief and motions filed. So what happened was, Dr. Matheson could no longer afford to maintain 2 houses. He had trouble maintaining the one house when they're all together. So what did he do? He started taking call service. He's 66 years old. He's taking OBGYN surgical call. So as he testified to Judge Janik, he would do a full day of surgery. Then he would do call service at 7 p.m. at night until 7 in the morning, then restart the next day. That was what he was doing for 3 years during this divorce. And as a result of him working 70, 80 hours a week, sleeping at the hospital, going to deliver babies in the middle of the night, his income went from about $250 to $275 up to $500 plus, because he was working the shifts of 2 physicians. And he testified, honestly.
Did the court, in reviewing the statutory factors for spousal support, say his potential earning ability was $275 roughly? Is that how they decided what his spousal support ought to be? Or what do they say about his income and B, his potential earning ability, and why they kind of reduced it from 600 to something different?
That's a great question. So what Dr. Matheson testified as a basis for the court's decision was, he thought, given his health, given the physicality of standing and doing hours-long surgery, doing call, that he could continue the pace he was on for a couple years. That he's on a year contract with the hospital system, that call is selective, but he's going to try to continue to do that because in order for him to pay the current spousal support order of nearly $9,000 a month, he has to make $180,000 to pay that. He's got to make over $150,000 just to pay the spousal support award. There's no tax benefit. So I think the court took into consideration that he was paying nearly $20,000 a month all in. He had to jump his work service from 40 hours a week to 80 hours a week. Contemplated his health, his physicality of what he actually has to be in surgery, and how long this is going to be able to continue. I heard the phrase lifetime spousal support. I've practiced law over 30 years. In contested divorce litigation, lifetime spousal support, that's not in the statute. That's not, that creature term hasn't been used since Wolf back in the 70s.
Is this particular order for spousal support subject to modification for amount during the term?
It is, simply because of the questionability of how long he's going to be able to get call service. What happens if he loses his employment contract? He could be a 67, 68-year-old surgeon, and what is the marketability of that? The record is clear. Dr. Matheson is a workhorse. He doesn't shy away. And I think when the court reflects upon the transcript, you'll see Mrs. Matheson would go on vacation weeks on end with the kids. He would stay and work and double time it because he didn't have any family responsibilities. This gentleman has not shied away from carrying heavy loads. But things are different. They've gotten divorced. They only had one real asset, a forced retirement account that was divided equally. And they had a house that they thought was worth a couple $1 million that ended up being worth substantially less. And those were divided. So all this money, I heard the word. Now, I did the 14-day trial. I did all the discovery. I had to suffer through all the games that were played by Mrs. Matheson. Hiding money, this is a new one to me because I don't see it in the judgment entry. I didn't see any proof of it in the trial because where is it? There's no bank account more than a nominal few $1,000s.
Did the trial court make findings as to their individual bank accounts that was awarded to each party?
You know, Judge, as you said, it's a long decision. I know there was a reference to the Scottrade account that was determined to be separate property of Mrs. Matheson. I know there was discussion about stock account of Dr. Matheson concerning Apple stock that the court did not view as to be separate property of Dr. Matheson's. The parties had nominal rolling accounts of no real substance. There were no accounts of $30,000, $40,000, $50,000. And we heard that Ms. Matheson throughout this trial was impoverished. The evidence was, and I don't want to dwell on the issue of her counsel. There was a game being played. Every time we had court, every time that we had an adverse hearing against Ms. Matheson for violating court orders, her lawyer would suddenly quit or get fired. And what the evidence showed is that there was substantial payments. $20,000 cashier's check when she's claiming she is impoverished, she can't pay her rent, but she can pay $20,000 to her lawyer who just quit before a trial. There was an appeal taken in July. If you recall, there was an emergency temporary custody when Ms. Matheson was hiding the minor child for months. Dr. Matheson was awarded emergency custody. 4 weeks later, we're supposed to have a full trial in front of Judge Janik at the end of July of 2021. Ms. Matheson files an appeal, not in good faith, because she didn't seek to set aside the magistrate's decision. She didn't file a brief. She didn't order the transcript. It was done to delay the trial. Then, when the trial came again, there was a motion to remove the magistrate. He was somehow engaged in some conspiracy. And it's important. There was a scorched earth to destroy this man. Tried to have him criminally prosecuted, tried to have his license revoked in state medical board. She didn't want to kill the golden goose. She wanted to annihilate the golden goose. And that's what she did throughout this litigation. The games that were played at trial with subpoenas not being served, subpoenas being hidden, subpoenaing his patients' records, not coming to court with their files so they couldn't turn over records.
Can you,
Sure.
counsel, speak briefly to the issue of assignment of Area 3, which deals with some of the things that were going on in court with the filing of witness lists?
Yeah, so the court had issued pretrial order concerning witnesses and exhibits. Ms. Matheson's counsel, Mr. Bunchy, did not timely file a witness list. He then, unbeknownst to us, had subpoenaed a fair number of people and accounts that requested document production, which he received. And we found out only through a pharmacy that he was attempting to recover patient information. So on the day of trial, we are presented with a list of potential witnesses and an expert report that hadn't been disclosed, or a report provided, and a large bulk of exhibits which he intended to use. That he either subpoenaed the information and didn't produce it under Civil Rule 45, Civil Rule 5, or we had never seen. And so the court, and Judge Janik did a great job in that if this was a small little bit of documents and we could get through it and we could take a break, and you know, I understand, I've practiced law for a long time. Sometimes exhibits miss the books. Sometimes you don't get something or falls through the cracks. This was systemic and it was intentional. And so the judge would take a recess, we would have a conversation about it, let's get the records, and we would receive the response, I don't have my files here. We've got a 14-day trial going on and the attorney doesn't bring his files. That's the type of thing that we were having continuously through the case, Judge.
Okay,
And
and
so-
I apologize, but we're, you've run out of time. I
Thank
said
you,
to
Your
go
Honor.
over because I asked that question.
I understand.
But if you'd like to summarize.
Your Honor, again, it was a long trial. There was a lot of pretrial litigation. I think the evidence was overwhelming of what was the agenda of Ms. Matheson and her counsel. And I think the judge called it a fair game. He gave everyone their opportunity to try their case. He bent over backwards, trying to accommodate
Okay, we got.
very irregular proceedings. Thank you, Your Honor.
Thank you. And I will allow you to have a little bit of extra time as well, so you will have 4 minutes for your rebuttal.
All right, thank you so much. During that entire time, I didn't hear any reason why he wouldn't be paying her lifetime spousal support. I didn't hear where those $200,000 is going. I didn't hear any of that. I didn't see it in the brief. And Your Honors had asked questions about it. I pulled the judgment entry. Like I said, it says exactly what I thought. Page 60. It says, according documents presented at trial, the party's loan debt was less than $100,000. Consisted of 2 Best Ag loans and 1 Lightstream loan. Okay, less than $100,000. Page 61. The existing loan debt shall be paid by both parties and the proceedings put in escrow of the sale. And it goes on to state $200,000, $100,000 from each party. Going where?
Opposing counsel indicated that seemed to indicate there was a finding of, there was a $240,000 of debt at that point in time would be divided. Is there anywhere, other than page on 6061, where the court makes findings as to what the debts were?
No. And I don't know where 240 came from. That's not in here anywhere. It's not in the record. He talked about the Machiavellian issues. He talked about the attorney hiding his file, the attorney playing games. None of that has anything to do with how are we paying creditors that we don't know. None of that has to do with spousal support. He talked about a significant mental illness. Again, I feel like he's just hiding from the court's actual questions.
But counsel, there is something to be said with respect to your assignment of error 3. If the record is the record going to show us that your client's attorney didn't file the witness list in the time frame that they were supposed to?
Correct, yeah, he did not file it in time. I'm not saying the attorney, did everything he was supposed to do, but that had nothing to do with Mrs. Matheson's spousal support, whether or not he filed the witness list in time. And as to assignment of error 3, the main thing was this trial started in November and concluded in March. And they're trying to say that, oh, this witness list we found out in November, we couldn't possibly talk about this expert in March.
Did the trial court make a fairly thorough analysis of the factors under 310518 in this case regarding spousal support?
Yes, pages of spousal support. And I pulled that as well when you had asked Appelli about the finding. It said, according to Dr. Matheson's 2020 tax return, he owed a gross income of $619,887 and a net of $565,525. So that was the finding.
Kind of using for his earning ability. I went through this and had a little trouble because the length of the opinion quite followed everything, but what were they saying he could earn to set the support at the $8,400,000 or $8,400 a month?
I believe that they're on page 63 where they say his tax return for 2020 at $619. That's what they're using. So they did outline that as well. As Appelli stated, Dr. Matheson's a workhorse. He works hard. Ms. Matheson became accustomed to it. She became accustomed to a living style. She became accustomed to taking her children on vacation. She became accustomed to living in a $1 million home. And I know in a divorce, everybody can't have what they want and they can't all live happily. But in this, Mr. Matheson got a windfall and Ms. Matheson got nothing. She got nearly nothing from the sale of the marital home. Out of the $330,000, she got around $40,000. That's not nearly equitable, and there was no testimony at all that needed to be paid out of the sale of that marital home, and that these debts shouldn't just be paid in the continual practice that Dr. Matheson has always done, moving things around and paying them. These are his debts. He created this problem, and I feel like the distributive award should have either been given to Mrs. Matheson or that $200,000 going to Mr. Matheson to pay himself back. Again, should have gone to Mrs. Matheson.
Well, they did seem to give some distributive award because they, at least it seemed to me, I understand from counsel, I have to understand that there was $240,000 in debt. They divided $200,000 equally and said, you pay the rest. But so they did give some form of distributive award and make him pay that additional money.
Right, they did make him pay the ones that he took out against the mutual restraints, which again says, where are we putting this $200,000? Because that is where that money is. It's in the ones that he took out against the mutual restraints. So that essentially, they're saying on one hand, we're not gonna accept that you took out these extra loans and created financial misconduct. You're gonna pay them, and on the other hand, here's $200,000, pay yourself back.
Okay, you're at the end of your time.
Thank you so much, Your Honors.
Thank you both for your presentations. The court will take the issue under advisement and issue a decision in due course. The clerk, of course, will mail a copy of that to you on the day that it is released, and the opinion will also be posted on the Ohio Supreme Court website. The court is now adjourned.